Madam President, it wasn't very long ago when the senator from Kentucky and I were here on the floor talking about drones previously. And I just want to make sure that it's understood that Senator Paul's passion, his intellectual rigor, and his devotion to these issues of liberty and security, which he and I have worked on together now for a number of years, is much appreciated. And I wanted to come for a few minutes and especially talk about what Senator Paul and I have discussed in the past, and that is how vigorous oversight, and particularly vigorous oversight over the intelligence field, needs to get more attention. It's not something you can minimize. It goes right to the heart of the values that the senator from Kentucky and I and others have both talked about, and that is that liberty and security are not mutually exclusive. We can have both. The senator from Kentucky and I often joke about how the Senate would benefit from a Ben Franklin caucus. And of course, Ben Franklin, famously said, in effect, anybody who gives up their liberty for security really doesn't deserve either. So the senator from Kentucky and I certainly have some disagreements from time to time on a particular judicial nomination. But I thank him for the time this morning, and I thank him for the opportunity that we have had over the years to make the case about how important these issues are, that the American people ought to insist that their elected officials put in place policies that ensure that we have both liberty and security. And I thank him for that, and we'll just have some brief remarks this morning, Madam President. Of course, the Senate is going to be voting today on the nomination of David Barron to serve as a judge for the First Judicial Circuit. His nomination has been endorsed by a wide variety of Americans, including respected jurists from across the political spectrum. Mr. Barron has received particularly vocal endorsements from some of our country's most prominent civil rights groups. Of course, the aspect of his record that has perhaps received the closest scrutiny in recent weeks is his authorship of a legal opinion regarding the president's authority to use military force against an individual who was both a U.S. citizen and a senior leader of al-Qaeda. Now, Madam President, I am quite familiar with this particular memo. The executive branch first acknowledged its existence 3 years ago in response to a question I asked at an open hearing of the Senate Select Committee on Intelligence. I followed up by working with my colleagues and pressing the executive branch to provide this memo to the Intelligence Committee. This month, of course, the administration made this memo available to all members of the Senate. And executive branch officials have now said that they will provide this memo to the American people as well. Madam President, this is, in my view, clearly a very constructive step, and I am going to vote yes on Mr. Barron's nomination. I do want to take a minute to outline that this whole matter is about much more than a single memo. It really drives home, Madam President, how incredibly important vigorous congressional oversight is. That is, of course, the mission of the Intelligence Committee, and it really is the mission of all of us. In his classic work on democratic government, Woodrow Wilson wrote that conducting oversight was one of the most important functions of the Congress. He suggested that it might be more important than passing legislation. Woodrow Wilson wrote, and I quote, "It's the proper duty of a representative body to look diligently into every affair of government and to talk much about what it sees." He added, the Congress must examine the acts and the disposition of the executive branch and scrutinize and sift them by every form of discussion. Woodrow Wilson said, if the Congress fails in this duty, then the American people would remain ignorant, and I quote here, of the very affairs which it is most important that they understand and direct. Now, Woodrow Wilson might not have been able to anticipate the size and scale of the modern national security apparatus. But I wanted to say this morning, his words are just as true today as they were a century ago. As the elected representative of nearly 4 million Americans, I have spent years now working from the theory that all of us here in the Senate have an obligation to understand how the executive branch is interpreting the president's authority to use military force against Americans who have taken up arms against our nation. And I have long believed that it's my obligation to make sure that those that I'm honored to represent in Redmond and Troutdale and Dallas and all across Oregon understand that as well. I believe that every American has the right to know when their government believes it is allowed to kill them. In the case in question, as I've said before, I believe that the president's decision to authorize a military strike in those particular circumstances was legitimate and it was lawful. And I have detailed my views on this case in a letter to the Attorney General that is posted on my website. So I agree with the conclusion that Mr. Barron reached in what has now certainly become a famous memo. To be clear, while I agree with the conclusion, Madam President, this is not a memo that I would have written. It contains what in effect are some, leaps, analytical leaps that I would not endorse. It jumps to several conclusions, and it certainly leaves a number of important questions unanswered. And I'm hopeful that making this memo public will help generate the public pressure that is needed to get those additional questions answered. And I'm talking here about fundamental questions like how much evidence does the president need to determine that a particular American is a legitimate target for military action? Or can the president strike an American anywhere in the world? What does it mean to say that capture must be infeasible? And exactly what other limits and boundaries apply to this authority? Mr. Barron wasn't asked to answer these questions, but in my view, Madam President, it is vitally important that the American people get answers to those questions. Those questions, in my view, are essential to understanding how Americans' constitutional rights will be protected in the age of 21st century warfare. And I'm saying this morning, I am going to stay at it until the American people get answers to those questions. Now, in addition to getting detailed public answers to these matters, another important step will be for the Congress to review the other Justice Department memos regarding the president's authority to use military force outside of an active war zone. Clearly, the most important memos on this topic are the ones that the Congress has now seen regarding the use of lethal force against Americans, but it's going to be important for the Senate to review the memos on other aspects of this authority as well. The past few years have shown that when the public is allowed to see and debate how our government interprets the law, it has led to meaningful changes in terms of ensuring that there are additional protections for privacy and civil liberties without sacrificing our country's security in a dangerous time. Now, it's unfortunate that it took Mr. Barron's nomination for the Justice Department to make these memos public. I will say here that it has been frustrating over the past few years to see the Justice Department's resistance to providing Congress with memos that outline the executive branch's official understanding of the law. When Mr. Barron was the head of the Justice Department's Office of Legal Counsel, I believe that congressional requests to see particular classified memos and legal opinions were appropriately granted. In the years, however, since Mr. Barron moved on from that position, congressional requests to see memos and opinions have frequently been stonewalled. And I use that word specifically, Madam President, frequently stonewalled. The executive branch often makes the argument that these memos constitute confidential, pre-decisional legal advice to the President. Here's the problem with that argument. The President has to be able to get confidential legal advice before he makes a decision. But once a decision has been made and the legal memo from the Justice Department has been sent to the agencies that will carry out the President's decision, that memo is no longer pre-decisional advice. It is the government's official legal basis for actual acts of war. And as such, in my view, it is entirely unacceptable to withhold it from the Congress. The Congress has the power to declare war, and Congress votes on whether to continue funding wars. So it's vital for the Congress to understand what the executive branch believes the President's war powers actually are. In that classic work that I have discussed from Woodrow Wilson, Madam President, Woodrow Wilson said, and I quote, "It is even more important to know how the house is being built than to know how the plans of the architect were conceived." And as a former basketball player, I often say that sections of the playbook for combating terrorism will often need to be secret, but the rule book that the United States follows should always be available to the American people and all of the American people. Our military and intelligence agencies often need to conduct secret operations, but they never should be placed in the position of relying on secret law. So I'm very pleased this morning that we know that the executive branch is going to provide this memo to the American people, and I believe that this constructive step must lead to additional steps that are equally important. This episode is an object lesson in how the United States Congress can use the levers that it has to fulfill one of the most important functions of government. And as my colleagues and I engage in our perennial discussions about how to make Congress more functional, I hope this is an experience that we will remember. Madam President, I yield the floor.